meghalayapost.news.
Meghalaya Pradesh Congress Committee MPCC kalapan bena bahkan betang Ïakhun haying bishar High Court persya Ïakhun jong Ngut ki MLA barim Shaka National People's Party NPP ban penpau bom de ban kinsting ya kahong upajba uskaturi ke MPCC Manuel Batwar ula ong bagaseng kan ya betang Ïakhun hadu benda poi Shaka Jingkun wan hadian bau speaker ke Assembly Thomas A Sangma ula kantai RCN Ïakhun kerpat ban Pynduh JinglongMLA jong ki tegit kon kini ki MLA ki balakan tiap na kaseng Congress Shaka kaseng NPP ki kentup yo ba Charles Mangar MLA ke Mahoti, Gabriel Walang MLA ke Nongstoin, Celestine Lingdo MLA ke Omsening, Bat Ronnie V Lingdo MLA ke Meliam. Henry ke Kongres kalakam bakani ke Ïasoh kalong persya ya kaan bat Deban Pynduh Ïakhun MLA jongki. Shushu ke Kongres kalakan no bo speaker lo Shimrai baklan dak baweng no Ïakhun ujor klam do bishar banya kabalong persya ya kinongrem kaan bat kirai jongki yang bishar bakli du kari India. Shushu ke MPCC kalapan pa bakalalong ke bapen kure banaj ru shadu Supreme Court lada don kam ban penti kena Ïakhun pet seng kanom dang Jashu Hakipor 11.
Why we holding this press briefing is basically we would like to at least inform the public at large as to the updates of the writ petition that we had filed in the High Court against the MLAs who had switched ships rather and defected from the party itself and joined the NPP, which happened in I think in August 2024. There are very strong grounds for which we would like to pursue this case because right from day one we keep on telling people that we will not take this thing very easily because it's very unconstitutional the way the thing has happened, whereby MLAs cannot just jump from one party to the other in their whims and their fancies, correct? So because of which I think you're all aware, we had filed a complaint with the speaker himself, and on very flimsy grounds, the speaker had rejected the petition in which we had filed, citing causes that anybody who files a petition has to be an MLA and so on and so forth. But according to the Constitution and according to a ruling by the Supreme Court, in fact, anybody who has any interest within the party and so on and so forth is allowed to do this. So because of which, again we lost the petitioner himself, the original petitioner, who's Ronnie Lingdo. He also left the party at a later stage. So we again had to pursue the entire case from the beginning again. So we had refiled it one more time, and the rejection from as far as from the speaker's table himself is again very flimsy. So we decided that we'll go to court, and for which we had gone to court, and we had filed with the court, and I think there had been 4 hearings. 4 hearings have had 5 hearings that has happened, and we stand on very strong grounds. I think the technicalities of the grounds basically Bakin Pham will brief you, and it is progressing very well. And why we keep on saying this, because I think we would like to send this message very loud and clear, not just to the present politicians but also to the future politicians of the state, that you know the rule of the land or the Constitution will not allow you just to do whatever you want and jump wherever you want just because you get either some benefits that has been promised by some parties or the other. Because at the end of the day we have this firm belief that it's a mandate of the people that you got elected, and for which we are going to pursue this case to its logical end. And we are very happy to tell you that in so far in all the hearings that has happened, it is very, very positive towards the case in which we have presented to the court, and we are hopeful that this will send a very strong message and will send a very big lessons to the future politicians as well of the state, that we should not take things too lightly when it comes to such thing as defecting from one party to the other.
See, in this case, like what I have said, 10th schedule is very much because they have the majority of merger, but the procedure of merger is different. So that's why on that basic on that the way they merge themselves to the party, to the other party, it's attracted this disqualification. So mainly in this case, if you look, a party congress, I just remind you, on 12th of August 2024, they have issued notice to two MLAs, Gabriel and Charles at first, and with Dr. Celestine. And Dr. Celestine on 16th, he appeared before in the meeting of the party, and he said that I don't want to leave. I don't have any intention to leave. Thereafter, on that day itself, on 16 August 2024, the party congress had suspended the two MLAs, so which mean that they cannot take the decision further.
So we had 4 MLAs, right, at that time. Normally, for them to qualify, when they want to do a defection, is basically 3 MLAs has to leave. Now the problem is only 2 MLAs left, okay, on the 12th of August 2024. Now when 2 MLAs left on the 12th of August 2024, we have proof that one MLA who also defected, of course, on the 16th, for 4 days he was still with us, which means that he came to the office, had meetings with us, registered himself, gave his attendance. We have every proof that he was still with the party, and not that we're just saying it, because he will obviously not sign on the papers and register himself for the attendance and attending the meeting and have discussions with us if he did not intend to leave, which meant that the first case was only 50%, which attracts for disqualification. But then only after 4 days, the third MLA also left. So it doesn't make sense. If you leave in one shot, right? You don't say that I will leave today, only 2 MLAs will leave today, and probably after a month or so another MLA will leave, and then you club them together and you say that no, you've crossed the 66% mark, which is totally unconstitutional in nature. So when we filed this petition, even with the speaker also, right? The speaker had answered to us. Everybody knew, because we also had all the proof that we had to prove it to him. But the only thing is that they had in fact given us replies on very flimsy grounds. Yeah, way too flimsy to even say that, you know, that like for instance, the person who had filed was a person who probably is not an MLA. I mean, these grounds is definitely not acceptable even under the constitution of the country. So, and we have proof that these are the kind of technicalities that we have probably from the legal cell have submitted everything to the court of law as well. And we believe so that whatever has happened has definitely been done in a very bad taste. And we would like, again, as I said earlier, that what Bakin Pam was saying, my colleague here, he's saying that we need to pursue this come what may. And we need to take this to its logical end, because it's extremely important, right? Because it's not just for us, but it's also for the future of the state as well. That politicians should not behave in such a way, and politicians should at least have what we call as moral standards, which is a far higher level than what they are as of today.
The last order of the High Court is that we just informed the court that service copy to the MLAs has been completed. So mean that by next date they will appear. They will appear before the court.
Okay. So who is the lawyer for the speaker?
The speaker is by himself AG. Advocate General. Actually, he should not be represent for the speaker, because it's different. AG is supposed to be for the government, not for the legislature.
And for the MLAs?
For the MLAs, till now, before I don't remember exactly, because before it was some other people, but now they have not yet come to the court. They have not appeared.
So you are sure that they will be disqualified?
So we are pursuing it, and we believe that as per what the steps that we have taken, it is slowly becoming more and more like a very, it's becoming a tight case. So we hope that it becomes watertight enough to ensure that we can take this forward. Yeah.
So, Speaker also in this case, that's why we went to High Court. He has not touched the merit of the case.
Yes.
Right now. Right now he just said that technicality that we cannot file because Manuel is just secretary. He is not a legislative. He is not a member of the assembly because, of course, according to the Meghalaya legislative for disqualification petition rules, is that only the remaining members. But we should remember that there are some judgment by the Supreme Court is that any member of the party concerned he can file it. So that's he has not called for hearing. He just dismissed on violation of natural justice without hearing, without affording hearing to the petitioner and nothing. So that's Congress Party to the Secretary of the MPCC, Manuel. We had presented the case before the Honorable High Court in Meghalaya. So at this juncture, the case is pending for hearing, and we have served the copy. We have already served the notice to all the MLAs, and of course, from the very beginning, the Speaker has also appeared before the High Court. So now the Speaker here is supposed to file the affidavit to challenge our petition, and at the same time, so we have in our case we have filed on the ground that under paragraph 6 of Meghalaya disqualification rules 1972, and along with the 10th schedule of Indian Constitution. So right now we are about 5 hearings taken place, but the case we are hoping that the case we are pursuing this case. We are the Congress Party have shown the seriousness that pursuing the case to the court of law, like our colleague has stated that this is that so that in the future will not happen anymore. Like we expect that this case will travel even to the Supreme Court also, and we are ready, and our legal team from Delhi, Manu Singhi as the chairman, and Salman Khurshid and some of the other senior advocate also, they are in Delhi. So they will we will see the order from the High Court, and after that, if we need to pursue to the Supreme Court also, we are ready to take up the case till the Supreme Court.
meghalayapost.news